Mr. Katz.
Thank you, Chief Justice. Chief Justice, in representing the IFP, the Inkatha Freedom Party, we submit that most of the questions that have seemingly exercised the court this morning have all been answered in our written submissions. And the IFP takes a principled stance as follows. Section 1, read with Section 102 of the Constitution, has the effect that the Speaker has no discretion, those sections properly interpreted. Every single motion of no confidence is to be dealt with by way of secret ballot as a matter of principle. The first principle that we talk to is Section 1, the rule of law. And the rule of law includes, as a proposition, separation of powers. And this court has said over and over that that separation of powers in the South African constitutional setting requires, it's not a choice, but it requires Parliament to oversee the executive. And when Parliament fails to do so, such as in Nkandla, this court will say so. So we disagree in a sense with Mr. Mpofu, who says separation of powers is not implicated in this case. It is. It's implicated at the heart of this case. And the heart of this case is how is the National Assembly to oversee the executive by way of, for example, a motion of no confidence, and as we've said in our heads of argument and in the IFP's affidavit, that needs to be effective and not toothless by way of a secret ballot. So that's our starting point. I want to deal with 4 topics with the rest of my time, sort of the start and the end of our argument. The 4 topics are, in paragraph 5 of our written submissions, we make the point that this case must be determined not with reference to facts, such as whether President Zuma is good, bad, or indifferent, not whether the ANC intimidated its members. Those are irrelevant. Similarly, the rules of Parliament are irrelevant for purposes of this case. The only fact that we do wish to turn to, which is a fact that will go to 2 aspects of this court's consideration, is, and that those 2 aspects are, 1, this question of direct access, the preliminary point that was debated earlier, and secondly, remedy, are the facts relating, and I do want to ask the court to focus on it, how the IFP have dealt with motions of no confidence over the last 7-8 years. And on pages 223 and 227 of the record, in paragraphs 12 to 24 of the IFP's
page reference
223 to 227, perhaps I should just ask the court to flip to it very quickly. On page 222, there's a heading, the IFP's historical and current position in regard to the issue. And then one sees a series of paragraphs in which IFP members, the Chief Whip, the lead, that's various other members of the IFP, members of Parliament, Mr. Ambrosini, Mr. Dandladla, Mr. Koos van der Merwe, who was then the Chief Whip, Prince Buthelezi, and more recently, Mr. Naran Singh, who's the current Chief Whip, all complained to the Speaker during various times that motions of no confidence should be dealt with by way of secret ballot. And the response from the various speakers to the IFP was silence. That factor will influence the court somewhat in, 1, whether to grant direct access, and 2, the nature of the remedy that this court may grant under Section 172 of the Constitution. So when I suggested that the facts relating to intimidation and otherwise are irrelevant, this fact of the IFP's long history of advocating for the matter as a matter of principle, not relating to particular facts, we say should have some relevance to this court's consideration. Turning to the next important aspect is the unemployed people's movement, the second amicus, makes what we would suggest are compelling arguments why this particular secret ballot, this particular motion of no confidence should be dealt with by secret ballot. But we, in our written submissions, in paragraph 44 and following, and in particular in paragraph 46, deal with all the points raised as to why this court should not only go to the coming up motion no conference, but should deal with all motions of no conference as a matter of principle. And there are a range of reasons why we suggest that, and we'd like to turn to those issues. We say in paragraph 45 that it would be not appropriate or desirable, and we would emphasize the interests of justice for this court to avoid the question as to the broad principle about as whether all motions of no conference should be done by secret ballot. As an introduction to that debate, we should make 2 points. The first is that motions of no conference are constitutional motions. Unlike other motions that come before the Assembly, this particular motion is contemplated and dealt with exclusively in the Constitution. Secondly, were we to be wrong in our primary submission that the Speaker does not have a discretion, the interests of justice we would submit would not be fueled when it comes to the question of how many times would the Speaker be taken on a review. The courts would be flooded with cases of the Speaker getting his or her discretion right or wrong on a case-by-case basis. So we would submit the interests of justice lead up to this court deciding the issue for once and for all. Are motions of no conference properly interpreted ones to be dealt with by way of secret ballot or not? In paragraph 45.1, we say, 1, we accept that there's no express equivalent. And Chief Justice, as Mr. Mpofu was arguing this morning, we took comfort from your suggestion of what we call the Ghana point, where the 3 reasons...
No, that was just the thinking aloud. It's not a suggestion.
But the thinking aloud led us to the conclusion that there are 3 reasons why, despite the fact that there's no express inclusion of a secret ballot in 102, properly interpreted, it does include a secret ballot. And the 3 points: 1, the purpose of an approach to interpretation. So the court is interpreting the Constitution, nothing else. No rules, it's irrelevant. We know that the Constitution can't be given effect to by whatever the rule says. That's an old, long-standing principle from Moodley prior to the Constitution, etc., by the then appellate division. 2, the fact, like in that case, in the Ghana case, it would be absurd. There, the Ghana court held to have a lower threshold than prima facie for purposes of referral of the judge. There, the judge would be referred to a commission, and there to be a prima facie case against the judge. It would be absurd not to have the same prima facie threshold in respect to the Chief Justice. We say similarly, when it comes to electing the President, when there's a contested vote, and for all the reasons that I think Justin Cameron put this morning, Chief Justice, you put to our learned friend a few minutes ago, it would be absurd to have a secret ballot in electing a President in a contested case, but rather not when he's potentially being removed. And thirdly, the point that's made in the Ghana case, the broader constitutional scheme. I think Justice Fruneman spoke of it this morning. So for those 3 reasons, we say, despite the fact that an express provision dealing with secret ballots is not included in Section 102, those 3 reasons suggest that's an irrelevant. 45.1.1, it's important we make this point, and it follows through our whole argument. The secret ballot removes the potential. It's not the question of whether there is a threat, but it removes the potential for threats. And we've referred to the notion of the sword of Damocles hanging over, well, it's a sword that was hanging over Damocles, who, in my Greek mythology, is not great, but perhaps the court could have regard to what actually happened there. The question was, when the person sat on the king's throne, there was a sword, and the sword hung over the king's head in case he abused his wealth or power. This was the sword. And our sword, our South African sword, is a motion of no confidence. That where there's a person, in that case the king, who has wealth and power, and it can be abused or otherwise, there needs to be a sword to say, King, better watch out. There's something that's going to hold you accountable. But that sword needs to have teeth. And the teeth that it must have is a motion of no conference, which can be legitimately, fairly, and properly debated and voted on. And if it cannot be, because there's no secret ballot, the sword has no role to play. 45.1.2. Importantly, and this ties into Mr. Unterhalter's argument, it removes the Hobson's choice faced by members, and says of the majority party, but it's not necessarily the majority party. Perhaps we should qualify our heads in that respect, who wish to vote in favor or against it, who may lose their seats or lose their position in the party. It shouldn't be a Hobson choice. They should be able to, every member of parliament should have a free vote, in the sense that they vote according to their conscience, according to what the Constitution demands. Then we, in 46.1, and we would ask the court, we'd emphasize the various aspects as to why we say the unemployed people's movement are wrong to only focus on this. But we want to pick up on a question that Justice Kampepe raised this morning, and that was this. The question was, why should there be a secret ballot when one of the founding principles is openness and transparency? And wouldn't there be a clash of some kind and an override on the question of openness and transparency over the question of secrecy? And the way we've dealt with it, in a sense, is paragraph 46.4. But our entire heads say we accept that there may be a clash of these values. But we say, were a secret ballot to always be the case in a motion of no confidence, the question of accountability is strengthened. And we say in paragraph 46.4, perhaps I should just read what we say, any potential for instability following a closed ballot is offset by the corresponding and equally serious instability which may occur if the potential for a motion ceases to be an effective check and balance on the executive conduct. Then the next sentence, this openness, Justice Kampepe, has the potential to undermine the legitimacy of government and to render toothless this important constitutional limitation on executive power. So what we say is this: to the extent that openness is a value to be strived for, it must also be strived for within the bounds of having an effective separation of powers, by having an executive which is subject to accountability. And to have openness may well compromise that very founding value of the Constitution, accountability. And that's the clash that perhaps can only be, we would submit, only be resolved by a secret ballot in all cases. And we emphasize the last sentence in paragraph 47, where we say, this court, it's numerous cases, Mazibuku case, certification case, has remarked the importance of a motion of no confidence to the proper functioning of South Africa's constitutional democracy cannot be gainsaid. It is an enshrinement of the separation of powers and limits the power of a single individual or institution, and to make the branches of government accountable to one another. So when we take those values that this court has so majestically described on numerous occasions, and we apply it to the interpretation of Section 102, the only conclusion that we would submit the court can legitimately come to today is that all motions of no confidence must be held in secret. So we want to come to remedy.
Before you do, let me just raise something that keeps on bothering me, and I don't know what to make of it. It is not only when a motion of no confidence is to be considered that the need for accountability arises. It arises when ministers have to come before portfolio committees, before an open session, and there is no room for you to duck and dive there. How then do you link the openness of the debate to the need to ensure that there is accountability at all times? Does it only relate to the president? Does it not relate to the ministers and the directors general when they come? And won't you be spotted? And don't the same consequences extend to those members of whatever party you may be concerned about being exposed to the repercussions you're talking about? How do we differentiate our argument in this regard to those other instances that happen so many times compared to a motion of no confidence? And yet you can't put a question to a minister hiding in somewhere. You must speak now, you must be seen.
Chief Justice, I'm going to try to answer the question.
Unless, of course, you ask it through a member of another party. You say, please, don't tell them it's me, but here is a question.
Yes, Chief Justice. You know, I've represented a number of political parties over the years, and we know that those types of mechanisms are used from time to time. But let me answer. But let me answer it as a matter of principle, and I suppose my answer will be a non-answer. But that is this: last year in December, many citizens of the country were glued to their TV sets when an ad hoc committee was appointed by the National Assembly to investigate the question as to whether, under the Broadcasting Act, as to whether the board of the SABC should be removed. By that stage, of course, there was no board because they'd all been resigned or fired. And what was interesting was, in the US terms, the bipartisan nature of the debate. All the members of the committee, from the wide spectrum of the different political parties in Parliament, all played a role in trying to hold the SABC to account.
Can I interrupt you? Is the reason why you remember it so vividly that it is hard to come by a thing like that?
And that's the...
what are the 3 incidents, and only 3 can you cite?
No, the point, Chief Justice, I think...
Just by the way, I know it's a peripheral issue.
Yes, yes, I think, yeah. And what was interesting about the response, social media and general media, how wonderful it was to have a parliament that was working in this oversight role. Now, I understand the question, and this is why I'm going to give a non-answer, as to why couldn't it be like that in every case when Parliament are called to account, or call the executive to account, whether it be the DG or the minister or whatever. And the answer is, I don't know. But what I do know...
take you, I'm sorry I'm interrupted, doesn't it take you to the President's position though, which is, that becomes a possibility when you stand, as in the US and other similarly structured democracies, as a candidate. It is known. Mr. Katz is a candidate for Yeovil. Although being a member of a particular party, he's a candidate for that. Now you can speak boldly because you have your own constituency. But now that's not necessarily the case here, where you are on a list. And you can be knocked off or knocked in as and when circumstances seem to permit. So you really don't have a voice. Is that not where the President's point perhaps has more force to say, you've got to tell the party that we put you there. You didn't put yourself there. So when we say this is our position, you've got to follow suit.
The difficulty with that argument by the President is this. Once they are there, the moment they are there and they swear in, they're not there at the behest of the party, they're there at the behest of us, the citizens. And that's the full answer to the question. The moment they swear their oath of office, yes, they managed to get to be able to swear their oath of office by dint of being on the party list. But that party list evaporates the moment they have sworn it in. So that's the full answer.
But to the original question, I think you've given me an answer, and that is you have no answer.
I have no answer. And the reason I have no answer, the reason that we have no answer is because depending on the nature of that particular oversight mechanism, whichever it may be, it may or may not be a 102 type mechanism. But we know in this case, we have a clear 102 provision, which gives oversight in a particular way to a particular branch of government, that branch being the National Assembly, and they are told this is how you hold account. Those other questions, such as the ad hoc committee of, the Nkanle example. The Nkanle example was a good one, where this court found there was a failure to hold account. I know that there are other cases continuing that debate. I want to turn, Justice Zondo.
Go back to the answer you have just given to the Chief Justice, or maybe it was not an answer, but a statement you have just made. You say that once members of parliament take the oath, then they cease to represent the party. they represent the people. How consistent is that with the position that I understand to be accepted, that the party can take you back, take you out of parliament anytime if they are the ones who put you into parliament? They can withdraw you anytime.
Justice Zondo, I'll try and answer the question, but before I answer it, I just want to qualify my answer to the Chief Justice directly. The answer that I gave, which was that once the oath is taken, the Member of Parliament is responsible to the citizens, applies at least in respect of Parliament's oversight role. It may not apply, and I don't say it does, and I'm making no submissions, in respect of an MP's responsibilities in other spheres of life as an MP. But certainly in respect of oversight, in respect of the executive, that principle applies. As far as the question as to whether or not a particular party may remove a member of Parliament from the list or from membership of the party if the member does not toe the party line is concerned, we would submit that the Constitution overrides that party principle. That principle as far as the parties are concerned. And it's not clear to us that were a party to discipline a member for not towing the line and voting in a particular way, in respect of motions of no conference, we limit our submissions to motions of no conference, whether that discipline would stand scrutiny.
Well, I wasn't having in mind only a situation where an MP is seen to have not towed the line by his or her party, but is the position not that a party may withdraw you from Parliament even if it's not for misconduct, or misconduct in a certain sense? Namely, for example, what if a party decided that, you know, in Parliament we have got too few women representing MPs. We need to increase the number. Therefore, we are going to withdraw some of our male MPs. So nothing to do with anything of not towing the line, but for that reason.
Yes, I'm not sure that that issue has come before this court yet. But as I understand the jurisprudence in the High Court and the SCA, that where a party withdraws a person who is a member of a legislature, whether it be local, provincial, or national, the party needs nevertheless to act rationally in a particular way. Issue hasn't arisen in this court, if I understand it correctly. But the question then would arise as to whether or not a particular member was let's call it replaced for particular reasons of policy or otherwise, and the rationality inquiry we would say be appropriate. I want to, before I turn to remedy, Chief Justice.
I'm sorry, Mr. Katz.
Yeah.
Mr. Katz, would I be wrong to say that the Constitution itself draws a line between arms of government and political parties? There's a clear distinction.
Yes.
When members of parliament act in the exercise of constitutional powers conferred on the National Assembly, they are not exercising those powers on behalf of political parties.
That's our submission, Justice Jafta, certainly in respect of 102 powers, yes.
What are the exceptions?
I don't, that's not, the point is, when a member of parliament exercises, when the National Assembly exercises power, it does so vis-a-vis the citizens and all citizens, irrespective of how the particular member became a member of that National Assembly, yes.
Can it be constitutionally permissible for any political party to act against a member of parliament for exercising their power as members of parliament in accordance with the constitution of the country, our supreme law?
We would suggest certainly not. Yes. Yes.
I think it's complicated. Anyway,
Yes.
let's not
Chief Justice,
go there.
before
I just think it's complicated, but it's neither here nor
It's
there.
what all this court needs to decide, we would submit for this
Let's
case,
confine it to this case.
motions of no conference, which is executive
Then
accountability.
it becomes easier.
Excuse me.
Then it becomes easier.
It becomes
Maybe.
easier. I don't make submissions when it comes to voting for a particular bill or for other purposes, Justice Jafta, but for purpose of this issue that is before the court, the 102 purpose, we stand by our submissions. And just on that, we want to refer to a paragraph of, paragraph 17 of a judgment of this court from last year. It's called the Democratic Alliance versus the Speaker of the National Assembly. It's reported in 2016, volume 3, essay 487. And the last sentence of paragraph 17 of this court's judgment, and I'll just read it, needless to say, for Parliament properly, we want to emphasize the words properly, to exercise its oversight function over the executive, it must operate in an environment that guarantees members freedom from arrest, detention, prosecution, and importantly, or harassment of whatever nature. And that's what a secret ballot does. It provides that type of environment which gives those guarantees. Absent this freedom, this court said, Parliament may be cowed, with the result that oversight over the executive may be illusory. The sword of Damocles with no teeth. That's what we're concerned about. And I turn to remedy. Now, the UDM, in their remedy, they suggest in paragraph 3 and 4 how this court should deal with the issue. And we have a slight difference with them, and I say slight, and we set that slight difference out in the IFP's affidavit. And that is in particular on page 219 and 220 in paragraph 5. In paragraph 5.1, we explain that the declaratory relief which the UDM seek in paragraph 3 should be tweaked somewhat, and we add the words read, which is after the fifth word, the Constitution, read with the powers, privileges and immunities of Parliament and Provincial Legislatures Act 2004. But in explaining that, we go on in the next paragraph to what we would say is a preferable reading of prayer 4, where we ask for declarators, or we suggest declarators, that say, on a proper and constitutional interpretation of the NA rules, the rules require motions of no confidence in terms of section 102 to be decided by secret ballot. And we would suggest that our paragraph 4 is neater and cleaner than 4.1 of the UDM's suggestion. And if the court is with us on that, we don't need 4.2.
Mr. Katz, but is it the rules that you would argue require, or is it the Constitution itself?
It's the Constitution that requires, but the rules properly interpreted require. And the rules need to be interpreted because of the constitutional injection into them.
No. Are you not asking us to read into the rules something that would flow from the meaning you prefer for the constitutional provisions?
Yes, yes.
And if we're doing that, is that not where considerations of separation of powers come in?
No.
Are we not rewriting the rules of the National Assembly now?
No,
Is it not enough just to give a meaning? This is what the Constitution means. And leave it there.
If the court comes to the conclusion...
Why should we read things into the rules?
If the Constitution... Yes. Section 102 of the rules, which is on page 260, deals with the issue. Perhaps, let me answer it like this. If the court's minded to grant a declaration as to what the Constitution means, and the answer is, the court gives the answer that, that the Constitution requires motion of no conference in terms of Section 1 at all times, then the Speaker, the Speaker would then be obliged in every case to hold a secret ballot, and that would be the end of it. The court doesn't need to deal with the rules. That must be the answer.
Speaking for myself, at some stage, I would really need somebody to show me why the rules should be interpreted
I accept it.
as requiring of the Speaker to have the motion of no confidence held by secret ballot.
I accept that. I accept that. I accept
Because whatever we do, we must know that Parliament still has its own power, its own authority, and it's on permissible,
Yes, Chief.
only on constitutionally permissible, under constitutionally permissible circumstances that you then begin to have the rule read the way it obviously does not read.
I accept that, Chief Justice. I accept that. Chief Justice, the last question that I'm going to be forced to just touch upon with I think, a minute ago, is although the IFP is a respondent, we've made common cause with the applicant, and we would submit that were the court to come to the conclusion, either in the main that the Speaker has no discretion, that there's always a secret ballot, or alternatively we'd be entitled to costs of two counsel against those respondents.
But have you people are too many now?
You say the too many of us, Chief Justice. Well, we've only got two. We've only got two counsel, Chief Justice. Look what we. Anyway, the point we believe that we've been helpful, and we believe that we are the only litigant, and I don't say party because of course we're a political party, who put up the rules. And the second aspect is the IFP have been motivating and striving for a secret ballot for many years, and it's only a question of form or substance as to the question of whether we are truly a respondent or effectively an applicant.
I doubt if we should have regard to that, Mr. Katz. We must just interpret the Constitution. We can't now look at the history of a party and say, you know, this party has been doing this, it deserves some credit, and therefore, no. We must just look at the law and interpret it.
And if the court is with us, as we would suggest you interpret, as we would suggest that the law should be interpreted, then we'd be entitled to our cost. As a piece of the court.
Thank you, Mr. Katz.
As a piece of the court.
Ms. Adams, we're going to take a lunch break for about 45 minutes. And it is that watch that we must look at. I think around 2:45, we should be back here. Thank you. The court will adjourn.